All right, are we excited? Are we ready to rock and roll? Are we ready to process a felony case through the Michigan courts? Well, I am. Yeah, I know, this is exciting stuff. So you have in your course pack handouts this little chart here. I'm going to have you pull that out and put it in front of you because as soon as I flash off this slide, you won't be able to see it anymore.
No, right after.
So pull that bad boy out.
Okay.
And we are going to process a case through the Michigan courts. All right, here we go. We're going to start at the beginning and process a felony case through. Now, I am intentionally and necessarily leaving some things out. We're not going to play the shoulda, coulda, woulda game because there's a whole bunch of minutia that could happen along every step of the way, but we're not going to do that because that would turn this 2-week lecture into a freaking semester-long lecture, and we're not going to do that. So I am necessarily leaving out some details, but I'm giving you enough that you should be able to go into a courtroom. In fact, really, you can go anytime now. The pool's open, go swimming. You should be able to go into any courtroom and watch the proceedings, and we'll help you understand. If you go to court, like between now and next week, come back next week and let me know, and we might even be able to help you write part of your paper in class, right? Yeah, so go to court, the pool's open, but you'll know enough to be able to write me a nice court paper. One that will make me smile and be happy and not start drinking alcoholic beverages again, okay? Well, I've been good. I'm trying to lose some weight, and you can't lose weight if you're drinking. All right, so I quit drinking, and I'm hoping you guys won't make me start again. Pretrial stages. Remember earlier in the semester we talked about the courts and we said that there were 3 general court stages and that we would develop them later. We would get into more detail about those later. This is later. So we had pretrial, we had trial, we had sentencing. So today we're going to focus on pretrial stages, and we'll finish that up on Wednesday and then move into the, well no, actually we'll move into trial stages some today too. But anyway, right, pretrial stages to begin with. Before we can start a case, we have to have a bad guy. Before we can have a bad guy, we have to make an arrest. We're going to define arrest as the lawful seizing and detaining of a person in response to a crime. The lawful seizing and detaining of a person in response to a crime. Now we have to have a person and a crime, right? I would like you to meet Texting Tina. Now, before you think badly of her for doing something as terribly dangerous as texting while driving, which she is obviously doing, I want you to understand there's a little story here. She's a good girl. And she's never, ever done this before because she knows, she understands fully that texting while driving is even more dangerous than drinking while driving. It is. She knows that, and she would never ordinarily text and drive. But let me tell you a little bit about her background. Texting Tina is a nursing student here at Delta. She desires very much to be a nurse because she is a compassionate, caring person. She's got a big heart, and she wants to help people. She lives with her parents. She's got 2 younger sisters. She's an A student. She studies really, really hard, and she's taking hard classes, you know, like anatomy and physiology and chemistry and stuff like that, like real classes, not like criminal justice, really hard ones. Ones that you have to study like literally hours for. Okay. Now, she is supposed to be meeting some classmates down in the Red Bricks Cafe for a study group because they're preparing for a really major anatomy and physiology exam. But she works part-time in a nursing home, and she's running late because one of her favorite residents in the nursing home passed away. I know. So she stayed afterwards to meet with the family and to give comfort and to receive comfort because she's pretty upset too. And so now she's running late. Because she's a nice person, she's a considerate and thoughtful person, she wants to make sure that her study group doesn't wait for her because she's running late. So she's going to just text them real quick, tell them to go ahead without her, she'll be there in a minute. Don't wait for me. Isn't that a nice thing to do? Isn't that a polite thing to do? Yes, it is. The only problem with what she's doing is she didn't pull over to do it. She thought it would be okay if she just looked down and real quick ripped off that text without realizing that in those few seconds she's looking down, she's hurtling through space quite a distance. And where is her attention focused on? Not the road. So next thing you know, boop, 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 boop. She flattens this beautiful little 6-year-old elementary school student who is leaving school, crossing the street to get into her mom's car. So her mom sees the whole thing. 10 teachers who are taking the students out to meet their parents and to get on the school bus, they see it too. 7 parents who are picking up their kids, they see it. And 9 little ghouls, children, they also see it. They see their classmate flattened, and they whip out their cell phones and take pictures. One of those little ghouls even has streaming video, which gets uploaded to YouTube. Wow. So, of course, they called the police. Are the police going to be able to arrest her? What do we need to make an arrest? Probable cause. Probable cause. So let's see, what do we have going on here? We've got tire tracks over the body of the child. We've got 10 teachers, 7 parents, 9 ghouls, students, pictures, video. Oh, and the cell phone. Do we have probable cause?
Yes.
We do. So to arrest her requires probable cause, which we most assuredly have. So can we cuff her and stuff her?
Yes.
Yep.
Hook her and book her? Sure can. Off to jail she goes. And now her bad day just got 10 times worse because of a moment away from the road. Isn't that tragic?
Where was the crossing guard?
Maybe she ran over the crossing guard too.
Just say it.
She had to send a pretty long text.
Why didn't she just call him? I know both are frowned upon, but
Do you call people, and how often?
yeah, I call people quite a bit. I prefer that.
Then
It's a lot
kudos to
quicker.
you.
Well, I prefer to call people myself too, but it's because I'm old.
There's no ifs, ands, or buts about what you're saying. It's clear.
Exactly, right? Well, either way, right? We could agree this is a no-no.
Oh, yeah.
Now texting Tina goes to jail, and the next thing that happens to her is called booking. Booking. So, what's the deal with booking? Are we so angry with her for killing that little girl, we just beat her over the head with a big, heavy book?
There'd be one type of punishment, but
Is that what booking is? That is not what booking is.
It'd be great, though.
What is booking?
Isn't that when I fingerprint them and all that, take pictures and...
Okay, yeah, we fingerprint them, we take their pictures, we get all of the important, pertinent information about that person. So we're going to define it as the administrative recording of the arrest. In other words, we're putting her on the books. Now, back in the olden days, before computers, there really was a book, and they would physically enter all of that information into a great big book, and that's why it's called booking. We just haven't changed the name because, databasing just doesn't sound as cool. Booking, book them. So texting Tina has now been booked. But because she has committed a felony, vehicular manslaughter, she's not going to have a bail until the judge sets one, right? So the next thing that she's got to do is to go to court. So here's where we start. District court arraignment. District court arraignment.
How long does it normally take?
For an arraignment?
Days.
Yes. From booking to the arraignment.
No, it depends on what time she's booked in. Those arraignments are usually done, most courts usually do arraignments in the morning.
Oh.
Not all, but most. So she might have to spend the night in court or in jail. Yeah. District court arraignment. All cases begin in district court, even if they're felonies. All cases begin in district court. Remember? So that's why we're here. We're in district court. We're going to define an arraignment as a criminal defendant's first appearance in court before a judge to hear the charges and enter a plea. So when you go to court to write your court paper, if you see a district court arraignment, here's what you're going to do. First, you're going to tell me that you went to district court. And from your Michigan judiciary sheet, you're going to tell me what a district court does, correct? And then once you do that, you can jibber jabber about who you talked to and who you met. But once you sit down in the courtroom, then you're going to tell me what proceeding you saw. If you saw an arraignment, then you're going to begin right here. I saw arraignments. An arraignment is, and you're going to give me this definition. Perhaps you have your court worksheet number 2 out also, because I'm giving you the answers for that right now. A district court arraignment is a criminal defendant's first appearance in court or before a judge to hear the charges and enter a plea. You would continue and tell me, did you see an in-custody arraignment or a walk-in arraignment? So let's talk about those. It's the same proceeding, it's just done 2 different ways. So in-custody arraignment. In custody means they are in the sheriff's custody. They're in jail. They're not out on bail. So the defendant has not posted bail, which would be the case with Texting Tina. She doesn't have one. It's a felony. The defendant has not posted bail, and the arraignment is done by use of closed-circuit television from the jail to the courthouse.
Like Polycom?
I'm sorry?
Is it like a Polycom?
I guess. And we're going to watch one in just a minute here. But this man here has been charged with murder, and he is in jail. The jails have a special video arraignment room that they take all of those people down to. And they call them up one by one to a podium. And this is what you're going to see in the courtroom. And this is what this guy sees on his screen. He sees the judge, but he doesn't see the rest of the courtroom. So this is only permitted for arraignments, which means if you're sitting in the courtroom and they fire up a TV, you're watching arraignments from the jail. You're watching an in-custody arraignment. If you go to arraignments, they're going to be very fast. They're going to be very rapid fire. Whether they're in custody, whether they're walk-in, which we'll get to in a minute, they're going to go very, very fast. Arraignments and sentencings are 2 proceedings that go really, really very fast. It would not be uncommon for you to see 8, 10, 15 arraignments, boom, 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 just rapid fire. I do not expect you to get all of that if you go to arraignments. That would be unreasonable of me. But of those 8 or 10 or 15 arraignments, you know what? 2 or 3 or 4 of them are going to jump out at you, and you're going to go, oh, wow, can you believe that? Write about those. And if you can get their name, great. If not, that's fine too, okay? But what I don't want is a court transcript, so-and-so versus so-and-so, blah, blah, blah. So-and-so versus so-and-so, blah, 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 because then I'm going to go, or I'm going to go, So don't do either of those, right? But of the ones that jump out, something like that would have jumped out at you for sure, right? A murder case. And so what you just saw in the arraignment is the judge told him what his charges were. Rather than taking a plea, because it's such a serious charge, the judge just said, you know what, I'm just going to enter a not guilty plea for you, and we're just going to go from there. Then he asked, would you like to retain an attorney, or do you need a public defender? And then somebody in the audience, presumably a family member, stood up and said, we're going to buy an attorney. We're going to hire somebody. And then the judge kept reading the possible penalties and whatnot of the crime that he committed. And then he brought up the fact that, oh, you have another charge that you failed to appear on. You're a very bad man. You didn't come to court when you were supposed to last time, so you are a flight risk, not only because you've been charged with murder, a very serious offense, but because you didn't come to court last time either. So I'm not giving you any bail. Did you catch that? So a lot of stuff happened in just a few minutes. You're going to be hard pressed to get names and all of that information, and that's okay. Write what you can on the ones that jump out to you. Does that make sense? Because they're going to go boom, boom, boom real fast. Walk-in arraignments. Same thing, except we're not using the closed circuit TV. We don't need to use that now because the defendant is out on bail. So typically misdemeanor stuff, they were able to bail out. And then once they bail out, we give them a bail agreement that they sign that tells them you need to come back to court on this day and time. And that's what they're doing right now. They're coming back. They're coming in under their own steam for their day in court. Some courts will do these at different times. They might have in custodies and then later in the day they might have walk-ins. Some of them do them together. They'll do the in custodies and then the walk-ins right behind it. Depends on where you go. It's the exact same proceeding. It's just done based on whether or not they're in jail or they're out free. Does that make sense? Okay. Anybody gone to court yet? Go to court. The pool's open.
I've been to family court, but I know that's not something we do.
Which what?
I've been to family court.
Oh, yeah. That would just be boring for your paper, though.
My biological mother.
Oh,
With
well, maybe
her
not.
Court,
Is there
so I go to that.
Is there a way to tell what court cases are going to be happening after such a thing?
Some courts have their dockets online and some don't.
So sometimes you just got to walk in and just...
Sometimes it's just walk in and play potluck. Yep. Make friends with the court security officer.
Like, hey, buddy. And that was what I wasn't sure about. Like, do I look it up or I go?
No.
And so I was like, I kind of check out and see what's what. See, if the worst comes to worst, I can always go a second time.
Say that again?
He said, like, if I can't, like, say I don't find something interesting and after that, I would like...
Oh, you can go to court as many times as you want. However long it takes you to write a paper. Yeah. All right, we're going to continue on. 4 things happen in an arraignment. So, in your paper, you're going to tell me that you went to district court. Tell me what district court does. You're going to define an arraignment. I went to an arraignment. This is what an arraignment is. You can, if you want, you don't have to, you can tell me whether you went to an in custody or a walk-in, or both, and you could explain those, and that wouldn't even be fluff. You could do that. And then you're going to tell me 4 things happen in an arraignment, and here they are, and you're going to explain them briefly to me. So the 4 things that happen are that we are going to advise the accused person of their legal procedural rights. The charges will be read, a plea will be entered, and bail will be set. Those are the 4 things that happen in an arraignment. So you would want to put those in your paper as well. You get those down, then we're going to walk through them one at a time. Paige, did you put your phone away? Let's begin with advising the person of their legal procedural rights. Now, this is not something that you would know from watching TV, so that means that you need to explain it to me. Remember, the goal of this paper is to convince me that you know what you're watching. So you need to write these papers to me like I'm a math major. Like I don't know the first thing about criminal justice, right? So advise of procedural rights. What are procedural rights? What is this we're speaking of? What?
Person right?
What rights?
Bill right.
Civil rights?
Bill right.
What kind of rights? No, police read Miranda. Courts don't read Miranda. Courts read procedural rights. What are procedural rights? Does start with a C. Not civil.
Constitutional?
Constitutional rights. Constitutional rights. Oh my God, my head hurts. I'm going to start drinking again. Don't make me do this. Remember this? Due process. Procedures followed by the courts to ensure a defendant's constitutional rights are not violated. And you would write that in your paper for me because I'm a math major and I don't know what procedural rights are, and apparently you don't either. So you're going to convince me now that you do. So you're going to say procedural rights are read. Procedural rights are, and you're going to tell me this right here. This is what you're going to write down in your paper. Procedures followed by the courts to ensure a defendant's constitutional rights are not violated. Often in court, what you'll see the judge do is read the legal procedural rights to everybody all at once. And the judge will say, does everybody understand? Does anybody have any questions? And of course, everybody's too frightened to ask, so nobody ever has any questions. So then they move on. Procedural rights are due process of law. Remember that? Way back in ancient history, what, 2 or 3 weeks ago? And of course, procedural rights are due process of law and refer to the constitutional rights of the accused. Now it's coming back. So on your paper, this is what I'm looking for right here. If you look in your course pack, you will find this handout as well. This is an advice of rights form. Now this is a misdemeanor advice of rights form, but it doesn't matter because the rights are the same. So we can use it for either. Now you have the following basic rights: to plead guilty, not guilty, to stand mute, blah, 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 to have a trial by a judge or jury, to have the assistance of an attorney, to have an attorney appointed at public expense if you're indigent. And let's scroll down here to 4, because 4 is the big finish. 4 is your trial rights. If you have a trial, you have the following rights: to call witnesses to speak for you at trial, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or remain silent, and, big finish, to be presumed innocent until proven guilty beyond a reasonable doubt. Beyond a reasonable doubt. Those are your procedural rights. Now don't write those all down because I would gig you for fluff on that. That would be fluff. You're going to be so busy writing other stuff anyway, you won't have room for that.
This one's different from that.
A little bit.
It's not too different.
No, that's for, oh, that's, yeah, they're combined. The charges are read. So texting Tina, well, we're going to hit her up with a vehicular manslaughter. And she killed somebody she didn't mean to. That's the manslaughter part. She killed somebody with her car. She didn't mean to, but oh well, the child is dead. So we're going to read the charges. The charges may be changed or modified at a later time. They're not necessarily written in stone. So in some cases, as an investigation proceeds, more stuff might be uncovered and the prosecutor might want to add charges. They might want to modify charges. Probably not in texting Tina's case because it's pretty cut and dried. But, you know, in other criminal cases, perhaps. Next, a plea is entered. Texting Tina, how do you plead? Now, she could plead guilty. If Texting Tina pled guilty, what would that mean?
if she'd be admitting guilt.
Okay, she's admitting guilt. She's admitting that she did it. Would we agree on that? Yeah. So she's accepting responsibility. Yes, I did do that. I was texting while driving, and I ran over that precious 6-year-old girl. All right. So if she pleads guilty, let me ask you this now. Does she get a trial?
No.
She doesn't. Well, you guys are pretty quick on that. Why would she not get a trial? I mean, didn't we just learn that was a constitutional right? I'm confused.
She chose not to have it by saying guilty.
Okay, she chose not to have it by saying guilty. What?
Nothing to prove.
There's nothing to prove. Okay, what is the purpose of a trial?
Prove that they're guilty.
To prove guilt. We're presuming innocence, so the purpose of a trial is to prove guilt. If she's saying she's guilty right now, if the words guilty came out of her face, why would we need a trial? There's nothing to prove, right? So she would not get a trial. She would give up her right to trial. She's going to give up her right to trial. Okay, so if she doesn't have a trial, now what happens next? We got all this stuff on our chart here, so what happens? Do we need to do all that stuff in between?
Sentencing.
Yeah, we're just going to go straight to sentencing because there's nothing else to be done with her now. So here's the problem. She's at an arraignment. She probably hasn't even had a chance to meet with her attorney yet, and here she is charged with a very serious felony. And she's saying guilty now? If she says guilty right now, guess what happens? It's game over, folks. See that game over light flashing? Game over, game over, game over. And she advances to sentencing, which means she is not going to have a chance to meet with the prosecutor and possibly work out a plea agreement, a plea bargain. She goes straight to sentencing, and the full weight of the law and the punishment that goes with it bears down upon her. Could we agree that this is not a very good thing to do at an arraignment? Especially if you're charged with a serious crime, right? A guilty plea at an arraignment, generally not a good idea. Okay, so she could plead not guilty. What do you think about that? If she pleads not guilty, what does that mean?
She wants a trial.
She wants a trial? Does that mean she's lying? I mean, my God, how many people saw her, right? We got pictures, we got a YouTube video. Does that mean that Texting Tina is just a dirty liar? Wow. You guys remember the Super Bowl a few years back with Justin Timberlake and Janet Jackson? They said Janet Jackson had a wardrobe malfunction, right, and everybody got a shot of her boobies. You remember that, right? That was pretty infamous. But the truth is, it wasn't a wardrobe malfunction. Nope. Justin Timberlake was, he was trying to cop a feel. He was going to honk her horn. And his ring got caught. And he panicked and jerked his hand away, bringing half of Janet's dress with him, in front of millions of viewers. Now, let's say we're going to ring old Justin Timberlake up on a CSC 4th degree, criminal sexual conduct in the 4th degree, which is the unwanted touching of the breasts, the buttocks, the genitalia, or other erogenous zone. Erogenous means it turns you on. Learned your word for the day. Okay, so we're going to ring him up on a CSC 4th degree. So Justin Timberlake comes to court, the judge says, how do you plead? And Justin Timberlake stands there and says, not guilty. Ha! Of all the unmitigated gall, how many people does one of those Super Bowl arenas hold? A lot. Thousands and thousands of people saw him right there. And millions of viewers on TV saw him. We all saw what he did. And he has the audacity to stand there and say, not guilty? Is Justin Timberlake a low-down, high-smelling, scum-sucking liar? Should we just take him out back and shoot him? No. Is it okay for Justin Timberlake to say not guilty, really? As it turns out, it is. Justin Timberlake is not a low-down, high-smelling, scum-sucking liar, and neither is Texting Tina. All it means when a person says not guilty is they would like their constitutional rights. Those constitutional rights that you just read to me, Your Honor, I would like those, please. Please give me my due process. Advance me to the next stage. I'm going to get an attorney and we'll go from there. So it really is okay to say not guilty. All it means is that you want your constitutional rights and you will advance to the next proceeding. But this is tough for some people because you know all criminals aren't bad people. Many of them are just people that made mistakes. So what happens is, well, back when I was a court deputy, I would take the bad guys from the jail down to the video arraignment room so they could have their video arraignment. Now, when you see the person at the podium on the screen, what you might not see is the deputy about 2 feet off, just off camera, there to keep order in case somebody goes bananas, right? So you'd have the guy here at the podium, and the camera's on him, and the judge says, how do you plead? And often it's a young person that didn't pay attention in their government class because they didn't think they needed to, and they're discovering now they should have. And their eyes get big, deer in the headlights. And they look over at me furtively like, help, help. That help look, you know the one? Help. So I'm over here just off camera. You know, help, what am I going to do? Not guilty. I'm whispering to him, plead not guilty, not guilty. And he's over here, he's, not guilty, Your Honor. And so I'm over there giving him the thumbs up, all right, yeah, we got it now. And all the way back to intake, when we're all done with everybody, I'm giving everybody a crash course on their constitutional rights that they didn't know because they didn't pay attention in their government class. Right? It's okay to plead not guilty. It is. All that means is game on. Instead of game over, game on. Now they can get an attorney. Their attorney could perhaps meet with the prosecutor. Maybe they can work out a plea agreement. I mean, it opens up the possibilities. Whereas if you plead guilty, you just slam the door on that sucker. Game over. We also have the plea of mute. Now, of course, you know mute means not to speak. And so what this means is that you would like to invoke your Fifth Amendment right to remain silent and not to incriminate yourself. So here's the deal, folks. You actually have to say the word. Your Honor, I plead mute, or Your Honor, I stand mute. You can't just stand there and go. Right, you have to say the word, Your Honor, I plead mute. If you plead mute, his or her honor says the defendant enters a plea of mute, the court will enter a not guilty plea on their behalf. In other words, you could have just pled not guilty, right? But the mute's there for a backstop because, you know, hey, not everybody understands that it's okay to plead not guilty. And, you know, some nice people are out there that made mistakes and they don't want to be liars. So we have mute there as kind of a backstop. So if they don't understand that it's okay to plead not guilty, then they can plead mute instead. And it's treated exactly the same. They advance to the next court proceeding. So far, so good? And if you look at your advice of rights form again, right there in number 1, to plead guilty, not guilty, or stand mute. If you stand mute, a plea of not guilty will be entered. Right there. You may plead no contest with the permission of the court. Well, let's look at that one. No contest, also called nolo contendere. Nolo contendere is Latin meaning no contest. If a person pleads no contest, let's say texting Tina pleads no contest, she says, Your Honor, I offer no contest to the charges. I won't dispute the charges, I won't fight the charges. Do with me as you will. Huh. Well, how about that? So what do we do with her? Does she get a trial? Does she?
No.
You got 2 no's and everybody else is remaining mute.
Would it be like up to judge discretion, like if they have the evidence?
So we got a maybe, we've got some no's. Does she get a trial?
Preliminary?
Yeses, no's. Boy, I got heads going on all directions in here. All right, let's go back to the purpose of a trial. Is what?
Presume guilt.
To determine guilt through an adversarial contest. So you've got the defense attorney going, she didn't do that, and you've got the prosecutor saying, oh, hell yeah, she did. It's a fight, it's a contest. So if one person says no contest, it means they're not going to fight. If they're not going to fight, imagine going to a boxing match or a cage fight, mixed martial arts or something like that, and the bell rings and both the fighters come out and then one guy just lays down on the mat. Well, that isn't going to be much of a fight. Don't you want your money back? And that's exactly what happens. When you plead no contest, you're giving up your right to trial because you're not going to fight, and you're laying down on the mat. We're done. I am not going to fight. Do with me as you please. So what does the court please to do now? What's left? Sentence. Yeah, there's nothing else we can do. Right? She's given up her right to trial, so we're just going to kick her right over to sentencing. Yes, sir.
So that's kind of like really similar to just saying guilty.
No, it's not.
Oh, no.
It's not the same as saying guilty. She is advancing to sentencing with no statement of either guilt or innocence. She's not going to argue about the charges. She's just going to say, I'll take whatever penalty you want to impose. Punish me. So it's not the same as a guilty plea. It's not. Now you might ask, why would somebody accept a no contest plea? Why would somebody take a no contest plea? Mostly you don't see them at arraignments. Usually you see them later on down the road as part of a plea bargain. But one thing that a no contest plea can do is help to protect from civil liability lawsuit. Now you just know that the little girl who texting Tina ran over, she's dead, but you know that her family is going to sue the socks off of texting Tina and her family, right? You know there's going to be a lawsuit. Now texting Tina feels horrible about what she's done. She would love to go to the court and say, guilty, punish me harshly, I deserve it. But she can't say that because if she admits guilt, then they take that guilty plea and they take that over into civil court where the standard of proof is down here at preponderance. And oh man, she just lost everything. That's a giveaway. So instead, now she can pound her chest and say, punish me harshly, I deserve it. But she's not admitting guilt. She's not saying she did it. She's not saying she didn't. She's just saying, I'll take the punishment. Make sense? Mostly we see no contest pleas as part of plea bargains. All right, so we've read the procedural rights, we've read the charges, we've taken a plea. Next, we're going to set bail. What's bail?
The amount of money you pay to get out?
The amount of money you pay to get out
I didn't say that right.
from jail. I'm confused. Are we bribing the judge?
Yeah.
Your Honor, I'm going to give you this much money, let me out of jail? All right, we're not bribing the judge.
And then the amount of money you pay till, to be out of jail until your court, your court date.
A certain amount of money you pay, wait a minute, back up.
Like you pay, like I know it's like you just said we don't say it like that, but like you pay to be released from jail until your court date.
Okay, who are you paying? You're not bribing the judge.
No, you're
County
paying.
clerk.
Yeah, clerk, yeah, that's what I was looking for.
Okay, so the money goes where?
I don't know.
To the court? Okay, what does the court do with it? Throw a big party? Pizza and beer? Friday night?
It's like a deposit.
To the jail.
Oh, they put it someplace safe. Like where?
That way, just
Like in the judge's desk drawer? Where would be a safe place to keep your bail money?
I mean, the bailout.
Maybe in a bank? Like maybe in a bank account for safekeeping that they can draw on it later? Yeah, like that. So you're paying money to the court holds it for safekeeping, and they tell you that you have to come back to court, right? All right, let's define bail first, and then we'll talk through that. I want to make sure that we're all clear on this. So we're going to define it as a monetary deposit. We might call it collateral. A monetary deposit for release from jail and to assure the suspect will appear for later court proceedings.
So if they return, do they get their money back?
They do, mostly. Yeah, hold that thought. We'll come to that in a minute.
Does it have to be money?
Or something very valuable.
Okay.
Card the right amount.
Yeah. Hold that thought. We'll talk about that in a minute. Bail is a monetary deposit or collateral for release from jail and to assure the suspect will appear for later court proceedings. Do we know that word, collateral? What's collateral?
It's like a count.
Like collateral is like you give some, like
Collateral.
it's like you give it. It's like never mind. I thought I had it, but
Collateral, anybody? Go ahead.
Oh, I think I was responding.
No, thank you, she says.
Something of value?
Something of value. Yes, exactly so. It is something of value. So by way of a personal experience, let me explain collateral. I live in Bay City, but I'm tooling around Saginaw one day. This was many years ago. And shopping, whatever. I don't even remember what I was doing that day, but I looked at my gas gauge and I realized I'm running on fumes. So I pull off in that 7-Eleven gas station there on Mackinac, Tittabawassee, and I gas up my vehicle. It was way back in the olden days when you could actually gas up your vehicle before paying. Yeah. So I fill my tank up. And then, much to my horror, I realize that I have just put a full tank of gas in my vehicle and I have no money. I spent it all. I didn't bring a credit card, and of course I don't carry my checkbook because that's just for bills. And I'm standing there basically with about $2 in my pocket and a full tank of gas that, I can't give back. Uh-oh. So I think to myself, well, I'm going to talk to the clerk. So I went into the clerk, I explained my situation. I said, I'm going to make you a deal. I'm going to give you my promise that I will come back with the money as soon as I possibly can. And for you to make sure that I'm going to do this, I'm going to give you something that is very valuable to me. And I gave her my deputy's badge and ID card. Right, this is back when I was on the sheriff's department. So I gave her my deputy badge and ID card with my name and my boss's name on it. Right, my sheriff, so she knows who to call. And I said, I would like this back. It's very valuable to me. So I will come back with the money and you will give me my valuable thing back. And so we made a deal, and I keep my end of the deal and I get my valuable thing back. Does that make sense? And so that's what I did. I went all the way back to Bay City. I got the money. I went all the way back to Saginaw. I gave her the money. I kept my promise. And then she kept hers and gave me my badge back. See how that works? Well, that's kind of what we're doing here, isn't it? You give the court money which they hold in safekeeping in a special account that they can draw from. You promise to come back to court every single time they tell you to. And if you do, you will get your money back. If you don't, what happens?
I buy money.
You will lose your money. You will lose your money and they will keep you in jail because you don't keep your promises. And so for most people, money is a valuable thing. It's a good collateral. They don't want to lose it. And yes, you really do get your money back. Some people say, well, no, you don't get it all back. Yeah, you do. Okay, let's say, for example, Ben owes me $20. I owe Ben $10. Are we going to pass bills back and forth until the cows come home? Or would it make more sense just for us to exchange the balance due? Right, so if I owe Ben 20 and he owes me 10, I'm just going to give him $10, right? And then we're square. And that's how it works with bail. Maybe you pay a $5,000 bail, but the court has assessed you $2,500 in fines and costs. So the court owes you $5,000, but you owe the court $2,500. Wouldn't it make more sense just to do balance due? And that's what happens. So you really do get all your money back. There are different kinds of bail. We have the cash bail. This is when the judge says, I want it all, 100% of that money, $50,000, texting Tina. You flattened that precious little 6-year-old girl. $50,000 cash. None of this 10% crap. Texting Tina says, I don't have $50,000. And the judge says, gosh, it sucks to be you. Off to jail you go. We can probably assume that she doesn't have $50,000, right? Now she has recourse. If she can't come up with that $50,000 cash, she could try to get a bail bond. So she is going to call a bail bondsman. A bail bond is a guarantee from a bonding company that the suspect will appear to face the charges. Bonding companies are not charitable organizations. They're businesses for profit. So first off, they're going to send a bondsman over to meet with texting Tina to find out if she's a good risk. And they don't want her to skip town because then that leaves them holding the bag. So they're going to interview her and determine that, well, yes, she's probably a pretty good risk. You know, she lives in the community, she lives with her parents, she goes to school here, she works here. She probably isn't going anywhere. So once they determine that they can proceed further because she's a good risk, now they're going to start the negotiation. They're going to want texting Tina to have some skin in the game here. Usually bonding companies ask for somewhere in the vicinity of 10%. I've seen them ask for more. I've seen them take less. It's a business agreement. It's a negotiation. But mostly somewhere around 10%. So let's say the bail bondsman said, well, texting Tina, you know, $50,000. Gosh, that's an awful lot of money. So we're going to want 10% from you. So she's got to come up with how much? $5,000, right? She's got to come up with $5,000. She says, well, I don't quite have $5,000, but I've got, you know, almost $4,000, and I've got a vehicle I can sign over. And the bail bondsman said, yeah, that would be acceptable. You sign over your vehicle, get the cash for us, and we'll write that bail bond for you. So this is what's going on now. Texting Tina promises the bail bondsman that she will come to court every single time she's supposed to. The bail bondsman promises the court that texting Tina will come to court every time she's supposed to. If texting Tina doesn't come to court, now who's on the hook for that 50 grand?
Bondsman.
The bail bondsman. Do you think that they're going to make any money that way if they're forfeiting bonds left and right? So what will they do to ensure that they don't lose that bond?
Isn't that why there's bounty hunters?
That is exactly where bounty hunters come from. There's your bounty hunters. Often they are agents of the bail bonding company. Sometimes they contract privately, but this is exactly where your bounty hunters come from because they don't want to forfeit that bond. So they're going to go track down they call them absconders. They're going to go track down the absconder and bring them back so they don't lose that money. Does that make sense? Yeah. All right. Next, we have the interim or 10% bail. This is the one most people are familiar with. It's probably the most common. The judge says, texting Tina, $50,000 interim, I need 10%. So now she has to come up with how much money?
5,000.
5,000 again. All right, so now let's make a distinction between that $5,000 she gave to the bail bondsman and the $5,000 she's giving to the court. If she goes to court every single time that she's supposed to, and she gave the money to the court, she'll get all that money back. If she gives the bail bondsman $5,000 to, you know, kind of stick his neck out for her on her behalf, she doesn't get that back. That's the fee. That's how they make their money. They're going to keep that no matter what happens. Does that make sense? So the question is, you know, when you're doing a bail bond, how bad do you want to be free? How bad do you not want to sit in that county jail while you're waiting for your day in court to come, right? Is it worth $5,000? No, to texting Tina it is. Personal recognizance. Sometimes textbooks call this release on recognizance. We're going to release you on nothing but your word of honor. No money. We don't need any money from you. Promises, sign on the dotted line that you will come every single time that you're supposed to, and we'll just let you go. Obviously, you might imagine that we're not going to give somebody charged with a serious crime a recognizance bond. But for people that haven't committed very serious offenses, why, they might get them. Different jurisdictions use them differently. Midland County, with its shiny new jail and all of that bed space, they're very stingy. They don't give these out very often. Bay County, who is actually a little bit overcrowded, and probably should be giving them out more freely, doesn't. They're also very stingy. But Saginaw County, with its overcrowded jail, higher rates of violent crime, well, they pass these suckers out like, you know, candy at a parade. So it depends on where you are as to how they use them. Now we're going from requiring no money at all and letting you out on your good word. We're going to spin a 180, flip the coin over completely, and we're going to look at no bond, no bail. This person is a high flight risk or they're a danger to the community. So maybe we've got a big league drug dealer. And we'll call him Pablo Escobar. And he's moving kilos of product into the country. If the judge were to say, Mr. Escobar, we're going to require from you $1 million cash bail. You know what old Pablo's going to do? Jaime, bring the briefcase. There's the $1 million. And old Pablo and Jaime are on the next jet back to Venezuela or Colombia or wherever they're from, right? We'll never see them again. So people like that, no, hell no, we're not going to give them any bail. Or maybe we've got a Jeffrey Dahmer. Y'all know Jeffrey Dahmer? Yeah, that whack job that was living over in Milwaukee, who would invite people home to lunch and eat them. Yeah. Now, if we give Jeffrey Dahmer bail and he gets back out, what is he going to do? He's going to invite more people home to lunch, isn't he? Hell no, you're not getting a bail. You're a danger to the community. So if you're a flight risk, you're a danger to the community, the judge is going to say, no, sorry, no bail bond for you. It's too risky.
Wasn't it in his case, like 2 years before he finally got caught, he was in a sexual assault case and he got let out on bail? And I'm pretty sure while he was out on bail.
Yeah, it was one of those, yeah. He was almost caught several different times, actually. But, yeah.
There was one time, wasn't there, like a kid ran out or something like that?
Yeah, that was another one,
Police were
yeah.
actually
And,
there
and he lied to the police, and yeah. Yeah, it's a good video on YouTube if you YouTube it, yeah. We have just finished arraignment. We have just finished arraignments. So arrest and booking, arraignment, okay, see where we are? We're going to go next to the preliminary examination. preliminary examination, sometimes called a preliminary hearing or a probable cause hearing. This is held in felony cases only. Felony cases only. So Texting Tina is going to have a preliminary hearing. Usually they're set within 10 days of the arraignment, unless the defendant wants to move it out further. Felony cases only. This is a formal hearing that establishes probable cause, which is why they're called probable cause hearings. Probable cause that a crime was committed and that the defendant committed it. Now, most of these are pretty perfunctory, because what standard of proof was needed to make the arrest? Probable cause. Okay, so in Texting Tina's case, we had the tire tracks over the body. We had the cell phone. We had, 10 teachers, 7 parents, 9 ghouls, children, and their pictures and their video. Probable cause? And mostly, you know what? The police are pretty good at their jobs. They understand what probable cause is. So if they had enough probable cause to arrest the person, generally speaking, by now, right, they certainly have enough probable cause to carry the case further. And that's basically what this is determining. This is the district court judge putting his or her eyes on the case and giving it a scan to make sure that the case is legitimate, that there is in fact enough evidence to warrant moving this felony case over into the circuit court where we learned felony cases belong, correct? So with probable cause, the case is then bound over to circuit court for processing, which is where felonies go. As I said, in most cases, these are fairly perfunctory. It's just kind of a formality. But occasionally, when somebody has hired their own attorney, they might turn it into a little bit of a dog and pony show. They want to show the defendant that they're earning the money that's being paid, right? So it turns into something that it can kind of look like a little miniature trial. In fact, it looks very much like a trial. You've got a judge, you've got the prosecution, you've got the defense attorney and the defendant, and you've got witnesses coming in. Now, the prosecution is trying to convince the judge that they have probable cause that Texting Tina did kill this little girl, and let's advance the case. The defense attorney, on the other hand, is trying to convince the judge that no, there isn't probable cause, and all of this evidence and these witnesses are bogus and baloney, and the case should be kicked out. So it winds up looking a lot like a trial because everybody's bringing forward their witnesses and their evidence. My question to you, student, is if you are sitting in a district courtroom looking at something that looks a lot like a trial, how would you know whether or not it was a district court trial or a preliminary examination? How would you know? There's an easy way. How would you know?
Where they're at, the defendant's at.
What do you mean?
Either standing at the podium if it's like an arraignment, or if he's sitting down.
Well, no, they would be sitting down in a trial or preliminary.
The clothes he's wearing?
Well, not necessarily. Well, they have trials without juries, don't they?
The bench trial?
And they could be free on bail, so they would be in their street clothes. How would you know? You're looking at it, it looks like a trial, but it might not be a trial. It could be a district court trial, it could be a preliminary exam. How would you know?
Just by what they're talking about. Isn't it?
Well, maybe sort of. You guys are making this too hard. This is criminal justice. This isn't anatomy and physiology. It's not chemistry. How would you know? Help me out, Dylan. You got this, right?
Wouldn't the judge say if it's one or the other?
No, the judge won't say. And if you walk in the middle of things, right, you wouldn't hear it even if they did. How about, you guys are going to slap your heads here. How about this right here?
Wow.
Right, because if it's a felony case, they wouldn't have the trial in district court, would they? District courts only try misdemeanor cases. Felony cases are tried in circuit court. So if it's a felony case, then you know it's a preliminary exam. If you're not sure what you're seeing, ask somebody. What is the charge? If it's a felony charge, you know it's a preliminary exam. If it's a misdemeanor charge, you're probably watching a district court bench trial. Does that make sense? Yeah, I know, it's a head slapper, isn't it? Let's bind the case over because we certainly have probable cause. See where we are here now? And we're going to come over here to circuit court. We are now in circuit court. The next thing that could happen is called a circuit court arraignment. I didn't even put it on the chart because mostly it doesn't happen. Mostly it doesn't happen. Usually it's waived by the defense. Because guess what? It's the same thing as the district court arraignment. They would read to them their procedural rights. They would read the charges. They would take a plea. They would set bail. It's exactly the same thing. So why in the heck would we want to waste all of that valuable court time doing something that's been done already? So mostly the defense says, we're good. We'll stipulate. The only time you might really see a circuit court arraignment is in the case of a violation of probation or parole. We're talking about somebody who was convicted of a felony and they were put on felony probation, which puts that into the circuit court jurisdiction, or parole, they got out of prison, which means it was a felony, and they violated the terms or conditions of their parole agreement. Those would be arraigned in a circuit court. Now, just so we're on the same page, because a lot of people like to use the terms probation and parole interchangeably, and they are not interchangeable. Apples, oranges. Probation is used before prison. The person doesn't go to prison. If you're on probation, you're being supervised in the community instead of being incarcerated. So you didn't go to prison, we're supervising you in the community, and you've got terms and conditions that you have to abide by. Parole is used after prison. You've been to prison already. You served some time, which means it was probably a serious offense, and you got an early release for good behavior under supervision in the community. So the similarity between probation and parole is that both are supervised in the community, but they apply to very different offenders. One is the offender who has not gone to prison, and they're just being supervised in the community. The other is an offender who has been to prison, and they got out early. See the difference? Big difference. So be sure that you're not mixing those up in your papers. That would be accuracy points. So if you're seeing a circuit court arraignment, that's probably somebody who was on probation or parole did something. They either violated the terms or conditions of their agreement, or they committed a new crime while they were on probation or parole. And they'll ring them up in circuit court rather than district court. Does that make sense? Okay. It's kind of funny. I actually had a student in my other class that had just watched one of those like day before yesterday, or no, I guess it would have been Friday. Yeah, and she was talking. I saw a circuit court arraignment. I'm like, well, those would be pretty rare. I said, it wouldn't happen to be a violation of probation or parole. Yeah, that's what it was. Yeah, that's what they are.
How do you get the name, like you're a felon? Like when you're calling somebody a felon, what's like the definition of that? How do you earn that?
So they've been convicted.
Well, you've been convicted of a felony.
Oh jeez.
Like robbery
Yeah.
or stuff like that.
Doesn't a felony stay on your record for 7+ years?
Mostly it stays on your record for the rest of your life.
What stays on for 7?
Misdemeanors?
No, misdemeanors are 2.
Well, no, actually not. Those can stay the rest of your life too.
Just
Because,
depends on-
what was it? I remember going to a job interview and somebody was talking about felonies, and the guy asked him if he hunts. He's like, no, I don't. He's like, "'Cause I can't use firearms because of a felony." He's like, I had one too. And then he's like, but years later, he's like, something got expunged or something. Like,
Yeah, you would have to go back to
so many
court
years.
with an attorney and get it
So,
expunged.
So often he double checked again, and then he was just fine. But is that even a thing? I don't.
It can be. It depends on the offense.
So, you know, like,
Wait, what?
my cousin went to court. He ended up with like 8 to 10 different felonies
cool
from
happened.
various B&Es or whatever, and he walked away with probation.
Yeah, good plea bargain.
How that works, isn't it?
Good attorney.
He was smoking and got high and he flicked the ashes. And
Now we know the difference between probation and parole, correct? Okay. Let us not mix them up in the papers.
he said like 10 years.
All right, next up, pretrial conferences. Now the word here is pretrial, which means it can happen any time before a trial. This could happen like right after arraignment or any time right up to trial. I just stuck it here because this is kind of when mostly they happen. Somebody gets bound over in a circuit court and they're going, oh crap, this is real. And now they want to make a plea. Now they want to talk to somebody, right? So pretrial conferences can take one of 2 forms. The first form is a discussion between the defense attorney and the prosecution in an attempt to reach a compromise. They're going to meet, the prosecutor, the defense attorney, they're going to meet and see if they can kind of hammer out an agreement, a compromise, a deal. And if they made this deal, what would we call that thing?
Plea bargain.
A plea bargain, that's exactly right. In the Motorola training film that we enjoyed so much, we saw an allusion to this, okay? Remember when the defense attorney came into the jail and he sat down in front of his client and he says, I've just come from meeting with the prosecutor. I was over there talking to him for over 2 hours and he's sticking with the attempt murder charge. So what he's telling his client is he just did this. He was over at the prosecutor's office trying to get the prosecutor to reduce the charges, to make a plea bargain, and the prosecutor would not do it. So, says the defense attorney in the movie, it looks like we're going to have to rack up 12 and go to trial. Remember that? So that brings us to the kind of pretrial conference that we did see in the movie. A discussion between the defense and the client, and the prosecution and the witnesses prior to the trial. In the movie, we saw the defense attorney go to the jail. And he sat down. He says, looks like we're going to have to rack up 12 and go to trial. And he tells his client, okay, there's going to be a jury right there, and you have to talk to them just like you came out of church. None of this bitch or shit vulgarity. Remember when he said that? And so he spent the rest of that scene coaching his client on how to speak correctly in court and how to answer questions if he should have to do that. Then they cut back over to the prosecutor's office, and we see the prosecutor meeting with Officer Kozub and Officer Murph, and talking to them about, okay, where did you handle the evidence? How did you handle the evidence? Did you bag it here? Did you mark it there? What about the issue of Miranda? Blah, blah, blah. So basically what they're doing on both sides is trying to get everybody's ducks in a row so that when it goes to trial, it doesn't turn into a big mess. So that the police officers can get on the stand and answer the questions appropriately. So that if the defense has to put his client on the stand, that the client can answer appropriately. Does that make sense? And that's what we saw in the video. We saw that behind the scenes pretrial conference. Now that's all behind the scenes. You won't see this in a courtroom. What you might see in a courtroom is once an agreement is made, once a plea agreement is made, they might go into the courtroom and put it on the record. It's called an acceptance of a plea. So you might see that. But all of this other stuff here, the pretrial conferences, those are behind the scenes. You won't see them. Now, if the defense and the prosecution reach a compromise, we agreed that it's called plea bargaining, right? Plea bargaining. We're going to define plea bargaining as a pre-conviction agreement. Pre-conviction, meaning there hasn't been a trial yet, nobody's been convicted of anything. A pre-conviction agreement where the defendant pleads guilty in exchange for some sort of leniency or concession from the prosecutor. For example, maybe a guy goes into a 7-Eleven store at 3 o'clock in the morning, puts a gun in the clerk's face, demands the money, which of course she gives him, and he leaves with the money and leaves this poor clerk terrorized, traumatized, still having nightmares, right? The prosecutor says, okay, let's make a deal. Instead of charging you with armed robbery, we'll agree to accept a guilty plea for an attempted robbery. Oh, well, that's quite a deal, isn't it? You think the bad guy's going to take that deal? Oh, heck yeah. Right? A full armed robbery versus an attempted robbery, that's going to be a lot less time, isn't it? So he says, yes, I will say guilty to an attempted robbery. Now, many people don't like plea bargaining. They say, it's not right. It's not fair. Imagine that poor 7-Eleven clerk who had a gun pointed in her face, who damn near peed herself because she was so terrified. She's still in counseling, she's still having nightmares, and she says, BS! I call BS! That was not an attempted robbery, that was a robbery. That man stuck a gun in my face and terrified me. I would like to say that we could do away with plea bargaining, but folks, it isn't going to happen. Plea bargaining has become an integral part of the criminal justice system. It's no different anymore than the arraignment or the preliminary exam. It's not going to go away. And I'll tell you why. Right here, 95%. Look at that number. 95% of all criminal convictions are obtained by plea bargaining. That's a lot, would you agree? Right now, with only about 5% of cases going to trial, look how backed up our courts are already. They're already all backed up for months. Can you imagine if all of those cases had to go to trial? 100% of all cases went to trial. The money first. Right, the cost to taxpayers would be overwhelming. Trials are expensive. They take a lot of time. We could run court 7 days a week, 24 hours a day, double, triple, quadruple our court staff, and we would never ever be caught up. So it's not going to go away. If every once in a while you get somebody running for office, they're running for prosecutor, and they'll say, well, you know, the guy that's prosecutor right now, he plea bargains all the time, and if you elect me, I'll do away with plea bargaining. Right? You know what? I call BS. Because he can't, and he knows that. He's just hoping that you don't know that number. He's hoping that you, the citizen, doesn't know the 95% statistic. And so everybody's going to go, oh, yeah, plea bargaining, that's a horrible thing. Yeah, we want to do away with that. So you vote him in, and then you know what he does? He goes, oh, sorry about that. I guess I can't. Right? Here's the other thing about plea bargaining. Like it, hate it, whatever. It's not going to go away. But in a plea bargain, you have got a conviction. It's a guaranteed conviction. When you take a case to trial, especially with a jury, juries are funny things. You don't know what a jury's going to do. I worked as a court officer for Bay County on and off for a number of years. And I would take the bad guy from the jail over to the court for his trial, you know, and I got to stay there too. I can't just leave. I got to stay there too to make sure the bad guy doesn't try to get away or, you know, assault the judge or something. So I'm sitting there hearing all of the testimony, seeing all of the same evidence that the jury hears. And at the end of the day, I'm thinking to myself, yeah, this is a slam dunk. The prosecutor has gone beyond a reasonable doubt with no trouble whatsoever. The jury will surely come back with a conviction. And the jury comes back and they go, not guilty. And you're going, what were they smoking in that jury room? I have seen people that I truly, absolutely, utterly believe committed horrible, heinous crimes, murders, rapes, child molestations, walk free. And sometimes people that I truly didn't believe did the crime, at least not what they were charged with, I've seen them get rung up. I sit there and I watch the case, I watch the evidence, and the prosecutor is just asleep at the switch, you know? There's more holes in their case than a block of Swiss cheese. And I'm thinking, we're not even close to beyond a reasonable doubt. We're not anywhere near that. Surely the jury will see that and they'll come back with the appropriate not guilty verdict. And the jury comes back and goes, guilty. I'm going, did they fall and hit their heads? I mean, you don't know what a jury's going to do. Juries are weird. And so here's the thing. You don't know what a jury's going to do. They let a guilty person go free, and where are you if you're the victim? At least with a plea bargain, they're saying guilty to something. And the second they say guilty to something, they are going to get punished. Now, it might not be the punishment you think they ought to have, but could we agree that something is better than nothing? And so that's plea bargaining. Now, don't write the red stuff down, but obviously you can see how it would save valuable court time and reduce caseloads. There's no need for a trial. We've got a guaranteed conviction. The minute they say guilty, we're done. Zip zop over to sentencing. It's over. The leniency in sentencing is attractive to the defendant. And hey, you never know. Sometimes we get more information about other crimes from them too. Let's say that the prosecutor, however, did not offer texting Tina a plea. Because, hey, she ran over a six-year-old child. And we've got to make an example out of her. I mean, young people riding around thinking that they can text and drive and this precious child has been killed, we'll make an example out of her. We're going to trial.